guys, this week we are not going with the book. This is a chapter on principles and rules of copyright that came from a PDF from Adobe Systems, and it just is a general idea of the copyright laws. So there is no book work, just this PowerPoint and a test. So let's kind of go through this. So first off, we need to determine what the words intellectual property mean, and we've talked about that in the past chapters. So intellectual property consists of anything that an individual has written or created. So anything that you guys create down in MAP is intellectual property. It might be music, text, pictures, photographs, sounds. Intellectual property is generally characterized as non-physical property that is the product of an original thought. So, you know, sometimes it is physical as far as having something on an SD card or printing something out. But the idea behind that property is that it is a creative, original thought. And that's what we're talking about as far as intellectual property, not the physical manifestation of it. The rights surrounding that control any physical manifestations. So think about it, what I just said. If you have an SD card with a photograph that you took, the intellectual property rights are going to surround how many times that can be printed, how it can be printed, that kind of thing. Intellectual property law does protect a content creator, which we all are, your ideas, and it assigns and enforces legal rights to produce and control those ideas. So copyright, we've talked about, is a protection for intellectual property. Copyright is a form grounded in the U.S. Constitution. It is granted for original works of authorship. Copyright covers both the published and unpublished works. So it does protect original works of authors, including anything literary, dramatic, like plays, music, artistic works, poetry, novels, all of these different things, even computer software and architecture, would be covered under intellectual property copyright. It doesn't protect any facts, ideas, systems, or methods. It may protect the way that those things are expressed. So a lot of people have different ways to solve a certain problem. So it's the way that they're solving that problem that is protected, not the facts of the problem. Now, a patent protects inventions or discoveries. So if you come up with a new type of car, that would be patented. Ideas and discoveries are not protected by copyright law, although the way in which they are expressed may be. So you may have seen patents where they kind of draw out their idea. So that it's not the actual idea, but how the idea is created. That would be a creation, so that is why it can be patented, and you can buy a patent. A trademark is going to protect words, phrases, and symbols. For instance, McDonald's is a trademark. Their logo, I'm loving it, that kind of thing. That identifies the goods or sources. So that would be a trademark. So kind of think about that for a second, the difference between a patent and a trademark. So when is your work protected? It is under copyright from the moment it's created. It's not legally put down somewhere. I showed you guys in the last chapter my copyright that I had. That is copyrighted from as soon as I made it. It's just it wasn't actually formally in the books until I sent it in to be copyrighted. So even if you just make something, it's automatically copyrighted. Do you have to register like I did? No, you do not have to register it. It is voluntary, but because it's already copyrighted. But if you register it, then if somebody steals your work, you can have a legal proof when you bring a lawsuit against them. So that is why people register, and that is why I registered my screenplay. They made us do that in school, of course, but it was for us so that we could learn that. Okay, so copyright is on the public record. It has a certificate of registration. It can be eligible for statutory damages and attorney's fee if you do litigate. If you sue somebody, you can say it was registered, and registration occurs within 5 years of publication. Is considered evidence in a court of law. So like I said, the reason you register is so that you could actually sue someone. Now, there's something called a poor man's copyright, and I actually learned about this when I was in college too. It's the practice of sending a copy of your work to yourself, because once it goes through the U.S. mail, if somebody were to, that's proof that it is yours, and that on a certain date, tampering with the U.S. mail is a federal offense. So that's called the poor man's copyright, simply because you have that post date to prove when it was created and sent to you. But there is no provision in the actual copyright law about this. So it's not a substitute, but definitely I know that everybody was doing that when I was in college when they would write something. All right, the fair use doctrine is part of the copyright laws. It states that a limited portion of material may be used without written permission for certain purposes. For instance, I am using this that fair use logo right there. Got that off the internet. And I can use that with fair use. A lot of the things that we use in class are being used, even though they are copyrighted by somebody else, and we are using fair use. So here is talking about what that is. It doesn't define what limited is. It just says that there are limited fair use, so you can't overuse it. It does require you to give credit to the author, and that's why a lot of times when we put things in PowerPoint, you will see a little thing at the bottom that says where this came from. I usually delete those and then leave them in the metadata of the PowerPoint so that they're still there, but they're not kind of junking up the way my PowerPoint looks. So I'm following the law if anybody were to check on me with fair use. The use of copyrighted materials like images and audios, it can be done for a transformative purpose. So for instance, I took this and I transformed it and used it to something else. This is actually what people do when they sample music to use in their songs. They are using fair use and they are transforming that. And of course, remember I said that fair use says limited. And since it doesn't say what limited is, that's why they will only sample just a tiny, tiny bit. So in case they're sued, they can say, well, we transformed it and it was limited. Mainly the way that they can transform that is held up in court would be parody, which is like making fun of something, or commentary, talking about it. So whenever fair use laws have come into question, the ones that usually win are to deal with parody. For instance, if you know who Weird Al Yankovic is, he always redoes songs and kind of makes fun of them as a parody, and he never gets sued because it is a parody of the song. So other types of fair use would be all of these. For instance, teaching, we are doing. Scholarship, which would be learning, which is what when I'll tell you, say in Photoshop class, you can go grab this photo off the internet and use it. In class, you are using it for scholarship. So this was considered a transformative use of copyrighted material. This movie, Naked Gun 33 1/3, you guys are probably too young to see this, but I mean, too young to remember this. But she was on Vanity Fair. This was really famous. And then this movie came out a year later, making fun of it. And they kind of got mad at them. And it was said this is transformative use. Now, this was not considered transformative use. If you recognize this poster, there was a lawsuit that was brought up against this poster, the Obama Hope poster, and it was not considered fair use. We will talk about that in a few minutes. So a parody is a work, so we're going back to parody. A parody is a work that ridicules a well-known art and imitates it in a comedic way. For instance, if your parents ever read you Goodnight Moon, they did one, Goodnight iPad, making fun of kids being on their iPad now. And if you remember the kids' book, The Giving Tree, well, they have The Taking Tree. That would be a parody. So even though it looks just like Goodnight Moon, and it's very, very similar, if they were to sue, they would say, well, we're doing a parody or satire of Goodnight Moon. Judges do understand by nature that parody demands some taking from the original work. It's fairly extensive use of the work is permitted in parody, like I was saying with the Weird Al Yankovic songs. Satire is, Mad Magazine is definitely satire. The use of humor, irony, or exaggeration to expose people's vices. So satire is very similar to parody, but parody and satire are okay with fair use. You can still get sued, but you have a leg to stand on. Compare that to the definition of parody. just so that you can kind of see the difference between these two. So y'all think about that for a second. And here's another kind of way to look at it. There's Weird Al that I was talking about. Yeah, he did. If you don't know who that is, you can look it up. This is his song "Eat It" instead of "Beat It" by Michael Jackson. So, obviously, Saturday Night Live is, right between parody and satire. So, yeah, satire is a little bit more sarcastic. This is what we would call derivative work. Copyright materials that have been altered or changed. So this was a photo taken from the Associated Press, and then this is an artwork by a really good artist that I like called Shepard Fairley. Now, derivative work is protected by copyright laws. So if you alter a copyright photo using a computer software, that photograph is still protected and you may not use it without written permission, which is what happened with this lawsuit. They determined that this was not enough of a derivative work. Now, transformative use would be different from derivative. Transformative, you completely transformed it. It adds something new, a new purpose, is not a substitute for the original work. Now, I would argue, if I was the judge in the Obama Hope poster, that it did transform it. That was kind of a big lawsuit. I kind of disagree with the ruling on it personally, but so new work has significantly changed the appearance of the copyrighted work would be considered transformative. It doesn't necessarily mean that fair use defense will succeed, which is exactly what happened with the Obama Hope poster. So derivative work, it contains elements of the original, but there's usually enough change to make it a work on its own. It does make use of the copyrighted material, like the poster, but it does so in a way that the work is fully copyrightable and the result is more original. Like I said, I kind of disagree with what happened with the Obama Hope poster, and that's just giving you my opinion. That's the fact is that it was considered derivative and not transformative. Okay, so for academic standards, we are allowed to use copyrighted work. But it does say that we have to say where it came from, which is why when you are writing an English paper, you have to cite where it came from. So the copyright material is higher. There's a higher standard for academics because scholars and researchers have a responsibility to share those ideas. Once again, this is why when you are writing an English paper, you have a higher responsibility to give credit when you quote someone else's ideas, because think about it, that is intellectual property, something that somebody has written. So when you are writing a research paper or an English paper, that is one of the reasons why you must quote, cite your quotations. As a researcher, you cannot paraphrase and not give credit for it. So you can't just take their ideas and change the words around. So here is the academic integrity policy at Tri-County Technical College. I would hope you would know what that means. One of the things to look at specifically is the term mosaic plagiarism. So mosaic plagiarism would be when a writer kind of rearranges the phrases and the clauses from the original, but pretty much leaves it the same, like reordering a railroad car on a train. It's still the train. So students kind of do that sometimes. That would be considered mosaic plagiarism. You can't just think about what a mosaic is and you move all the little pieces around. It's still the same thing. You cannot use copyrighted material without written permission from the creator of the material or its copyright holder. Even with fair use, which is, like I said, when I use things like this, I keep the metadata of my fair use in my PowerPoint because that is giving permission. Material can be protected even if it does not display the copyright symbol. Even if no mention is made regarding the copyright, you must assume that all material is protected. Penalties for violating copyright law vary. They're really only going to come down on people that are making a lot of money off somebody else's copyrighted work. If you break that law, you probably just will get an email or something that tells you to stop using that material. Do be very, very careful on the web. because whoever, say for instance, you might have your website hosted with GoDaddy. You've heard of GoDaddy. GoDaddy may take you down because you've got too many copyright. You're breaking the law, too much copyrighted material on your site. So, you may get away with it, but then your website is taken down because GoDaddy doesn't want to get sued. This is just telling you what you need to do. You can ask for permission and follow what they want. You don't have to have a copyright notice. Keeping whatever symbols they have on there is a good idea, and knowing the name of your copyright. So just kind of look at that kind of thing. Phonographic records and sound recordings kind of have a different thing. So the symbol of P with a circle is usually what is on sound recordings. Then they have the year that it was created and the first year that it was publication, first year that the recording went out. So you need to go ahead and make sure that is on all. You have to have all three things for any sound recordings according to the Copyright Office. Here is an example of the little copyright that is on. This was a CD. Authors do own the exclusive rights to their compositions. This is for audio again. It's considered to be intellectual property, but you can sell or transfer or inherit it. For instance, Prince has died not too long ago, and his family inherited all the copyrights for his songs. I know that the Beatles music was purchased by Michael Jackson, and then Paul McCartney was trying to get some of it back and that kind of thing. So you can sell the rights to these things. Now, music or lyrics are different than the actual recordings. So you cannot reproduce the music or the lyrics. You can't distribute the music or lyrics for free. You can't play or record the music or lyrics in Publix, even if you own the CD. And this is why if you've ever been to, say, a karaoke place that's doing karaoke, when the songs will come up, it will go in the style of, whoever, Carrie Underwood. Because it's not saying this is actually Carrie Underwood's song. It's just in the style of Carrie Underwood's song. And that's kind of how they're trying to not get sued. So, public domain. Oh, and look, this photo is licensed under Creative Commons. You see, I left that one on there. There's the Creative Commons stuff. Copyrights do eventually expire. All compositions that are not protected under the copyright law are said to be in the public domain. And if you can prove that a composition is in the public domain, you can use that work, and then you can rearrange it and all kind of stuff and sell it. The reason Happy Birthday is on here is it went out of copyright and into the public domain in 2016. If you'd ever been, maybe when you guys were younger, to a restaurant and they came over to sing Happy Birthday to you, but they didn't actually sing Happy Birthday. I know Applebee's used to be like, happy birthday from Applebee's to you. They wouldn't actually sing Happy Birthday because it was copyrighted. And you wouldn't actually hear it in movies because it was copyrighted. The copyright did expire in 2016. So now you can sing Happy Birthday in any movie or in a restaurant and not get in trouble. So all of these things would be considered in the copyright for musical recordings. So for instance, Mary Had a Little Lamb is in the public domain. It was written a really, really long time ago. It can be freely used by everyone. You can sing Mary Had a Little Lamb. However, there are no sound recordings of Mary Had a Little Lamb that are in the public domain. So for instance, if Carrie Underwood did a version of Mary Had a Little Lamb, that would have to have a separate copyright, and it is not in the public domain, even though the song Mary Had a Little Lamb is in the public domain. So hopefully that makes sense. So it is imperative that you understand the difference between a musical work and a sound recording. So the rule of thumb, anything before 1924 or earlier is in the public domain. Now, of course, that year, the year 2024, is going to go up every year. If you were to look at this PowerPoint in 10 years, it would be 1934. So that does change. Eventually, all sound recordings are under copyright protection until 2067. And that's because of the amount of years that it takes. Outside the U.S., has different laws. So this is these K-pop songs and things are not under U.S. law. So it depends. What I was saying about 1924, that's because it's either 50 or 70 years or 95 years. It kind of depends on what the copyright is. So that's why we've got that 2067 for copyright protection. Now, I do want you to really realize the difference between copyright and royalty-free. So you've seen that on the internet. A royalty is a payment made by one party to another that owns a particular asset. So for instance, back to Carrie Underwood, every time her song is played, particularly in a movie or a TV show or even on the radio, she gets a royalty. Every time Friends is watched on Netflix or HBO, it is the actors and the directors get a royalty. They get a payment every time their copyrighted work is used. So that is what a royalty. So when you see the words royalty-free, it just means, it doesn't mean that it's free. It means you're not going to have to pay them every time you use it. So let's talk about it again. Royalty-free does not mean that it is free. It means that you do not have to pay them every time you use it. So that just, you don't have to pay an ongoing fee. So if that means if you buy a song and it says it is royalty-free, that means you can use it as many times as you want and not have to pay for it again. Now, some things are free and they're royalty-free. Think about the difference between those, because a lot of people think royalty-free means free. Sometimes it is, but not always. It doesn't mean it's copyright-free. They still own the copyright. They're just saying you don't have to pay us every time you use it. Free content and free information is free cultural work. It may be content, it may be royalty-free or not. Open source software is considered the same thing. Creative Commons is what we call things that are both free and royalty-free. So they still hold the copyright, but they say that it is in the Creative Commons, that you can use it creatively. It's fine. So most of the stuff that we do, if we're not getting paid for it, would fall under Creative Commons. Now, a lot of things will be put as open access, which refers to it's free, there's no royalty, there's nothing. A lot of authors will put their books out with no digital rights management and say that it is open access. Linux computers are open access and free. I'm sorry, the software in Linux computers. So, content is used to describe certain intellectual properties that you don't have to pay royalties to is royalty-free. You have to put that on there, though. They can also gain rights to it if you have to sometimes pay for it, but then you don't have to pay for it again. So that is the end of this chapter, and I hope you have enjoyed it. Feel free to look up any more of this information on the internet, and I will see you when I see you.